Oh, yeah.
ये मोबाइल से होगा कहीं ऑफ होने वाला
ज्वाइनिंग हो गई ना,
ज्वाइनिंग हो गई ठीक है
हम जा रहे हैं सर, देख लेंगे चाहिए अभी आ जाए। बहुत अच्छा इम्पोर्टेंट है।
हाँ
Dear participants, we can start the program. Ruchi Singh.
Yes, sir.
Ruchi.
Yes, sir.
We can start the program.
Yes, sir. Yes, sir.
Okay. Okay. Good morning, all of you. And today, my guru and the stalwart in the field of law, Professor Dr. Devendra Prasad Verma, former Dean Faculty of Law, Banaras Hindu University. Now today, we have to hear the lecture, and that lecture will be very important. So I feel you be more serious to hear the lecture, and we get the blessings of sir, and always we are getting the blessings. Sir, sir, you may start the program, sir. You may deliver the lecture, sir.
Okay, thank you very much. And first of all, good morning to everyone. The topic which I have selected for this refresher course on human rights is International Bill of Rights, Principles, Substance and Procedure. To some of you, the term International Bill of Rights may appear new because most of us have heard about Universal Declaration of Human Rights or International Covenant on Civil and Political Rights or International Covenant on Economic, Social and Cultural Rights. But from where this word has emerged, and in order to understand the nature and scope of International Bill of Rights, first of all, I must tell you that the recent documents of the United Nations have used the word International Bill of Human Rights. But the word which I have selected, it is International Bill of Rights. And actually, this term was first used in the conference of, in the International Conference on United Nations, which had taken place for the establishment of the United Nations Charter, and these conferences had taken place at San Francisco in 1945. At that time, preparation of International Bill of Rights was of fundamental preoccupation of the United Nations. It must be known to everyone that the word human rights was first used in the United Nations Charter Earlier, this was known as natural rights or rights of man. But for the first time, the term human right was used in 1945, and this word has entered into the vocabulary of the United Nations Charter. There are 7 articles in the UN Charter which speaks about human rights and fundamental freedoms. But the great difficulty is that nowhere human rights has been defined in the Charter. The reason, and it is the peculiar thing, once there is a fundamental preoccupation of the United Nations to prepare International Bill of Rights, but what are human rights? It was not known to the people before 1945, and we had learned it by natural rights or the rights of man. It was only the brutalities committed during the Second World War, the barbarous act or the Holocaust which had taken place during the First World War. This became a source of inspiration to the international community that we should think about the rights of man, and the word human rights was first coined here. Even the preamble of the United Nations Charter refers to recognition of reaffirmation of faith in human rights and fundamental freedom. To repeat it again, I must emphasize the word which has been used, reaffirmation of faith in human rights and fundamental freedom. What does it mean? Human right has not been defined. Rather, United Nations Charter begins with the word that we, the people of the United Nations, are reaffirming. We have already affirmed our faith in human rights, but we are reaffirming our faith in human rights and fundamental freedom in the preamble of the United Nations Charter. There is Article 1 of the Charter, which is known as the purpose. There are 4 purposes of the United Nations Charter, which have been outlined in 4 paragraphs of Article 1. Paragraph 3 of Article 1 states UN commitment for promotion and protection of human rights and fundamental freedoms around the world. It is important for us that United Nations have 4 purposes, and the one of the purpose is promotion and protection of human rights. Not only this, the responsibility has been given on the states of the member states of the United Nations as well. There is Article 55C, paragraph C of Article 55, which refers to the UN commitment for respect for universal rights, universal human rights around the world. And the different member states of the United Nations have pledged to take separate action or joint action with the United Nations or other states towards promotion and protection of human rights. Thus, there are 7 articles which in the UN Charter which refer to human rights and fundamental freedom. Now, the point is that if states have pledged to promote and respect human rights, these states want to know what human rights are to be protected. That is the great problem. Once United Nations Charter has not identified, once the preparatory commission for the establishment of the United Nations had requested after the establishment of the United Nations on 24th October 1945, in December, Preparatory Commission for the Establishment of the United Nations had requested Economic and Social Council to establish Commission on Human Rights for formulation of International Bill of Rights. The word International Bill of Rights comes there in the recommendation of the Preparatory Commission on the United Nations. Immediately thereafter, the work started. It was resolved by the General Assembly that Economic and Social Council should be directed to constitute Commission on Human Rights for the purposes of preparation of International Bill of Rights. And in this decision of the General Assembly was taken in February 1946, and it took time, and the Economic and Social Council established a nuclear commission. And the first of all, this Commission on Human Rights was constituted in a nuclear form only for the purposes of formulation of International Bill of Rights. Once this commission started its work, that this International Bill of Rights be prepared, the difficulty was that whether it should contain only declaration of the fundamental principles of human rights, or there should be legally binding nature instrument for human rights as well as implementational mechanism. These were the challenges, and the work was enormous. Looking into it, the United Nations, at the request of the Economic and Social Council, constituted a permanent commission on human rights, which was earlier Nuclear Commission on Human Rights. And thus, the work started in 1947, working towards formulation of International Bill of Rights. At the very outset, the Commission recognized the difficulty. What would be the nature of International Bill of Rights? Should it be a document containing only the contents of declaration? Was very important for International Bill of Rights, that once the states are expected to respect human rights, they must know, and human right must be defined, human right must be clarified, human right must be exposed, human right must be identified. Therefore, there was a need that the list of human rights must be calculated. It must be defined clearly or mentioned clearly, so that the member states may know will consist of three parts. The first part will be a declaration. Second part will be a binding instrument, and the third part will be implementational mechanism. Therefore, the concept of International Bill of Rights consists of three important parts: Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, as well as International Covenant on Economic. And so far as implementational mechanisms are concerned, we come across with different optional protocol of the ICCPR and ICESCR. In this way, the work had started. About few days back, the international community has celebrated the adoption of Universal Declaration of Human Rights. About 73 years back, on 10th December 1948, the World General Assembly Resolution number 217A had adopted Universal Declaration of Human Rights without any objection. Therefore, it is stated that Universal Declaration of Human Rights was unanimously adopted by the General Assembly. This UDHR found expression in the both two international covenants: International Covenant on Civil and Political Rights, International Covenant on Economic, Social, Cultural Rights, as well as in the two optional protocols. Therefore, it must be very much clear to everyone that International Bill of Rights is such a document which is divided into three parts. First part is theoretical nature, or generally it is considered a moral obligation which deals with the fundamental principles, which identifies which are human rights, and these human rights, which has these three are put together with International Bill of Human Rights, comes into being. Now, at this place, it must be known to everyone that the thread of International Bill of Human Rights starts with Universal Declaration of Human Rights. It comes to the two international covenants, and the third was international mechanism. What is important here that initially International Bill of Human Rights was conceived as a binding instrument, the provisions of which would be enforceable by international machinery and methods. But it did not take long time to find a way out of this dilemma of binding obligation. And since 1948, once we had adopted the Universal Declaration of Human Rights, we go to 5th May 2013, where all the formalities with regard to implementational mechanisms were completed. Therefore, now my lecture would be divided into three parts. Number one would be the principles. The second one, the part will be dealing with the legally binding instruments, and the third part will be dealing with the implementational mechanism. That's why I have mentioned three things. Number one is principle, number two is substance, and number three is procedure. Now, coming to the principles, what are principles? If we look to the Universal Declaration of Human Rights, the word we generally say, and we say you use the word that these are merely of declaratory nature, these are merely of recommendatory nature, because the term declaration used in the text of the Universal Declaration of Human Rights. Now, what are the fundamental principles? There are 8 fundamental principles which has become a part of International Bill of Rights. And I take these 8 principles from the preamble of the United Nations, preamble of the Universal Declaration of Human Rights. The first fundamental principle of International Bill of Rights, which comes out from the UDHR, is that there is recognition of two things: human dignity and equality. And about these two things, the fundamental principles mentions that human dignity and equality are not only inherent, they are inalienable rights. These are the two terms which have been used in the principles, that human dignity cannot be taken away, equality cannot be taken away. These are inalienable rights. We are born with these rights. The first article of the UDHR mentions that all human beings are born free and equal in dignity. Once we are born with these rights, these are our birthright. These rights cannot be taken away by any state, by any government. These are inalienable rights, and these are inherent rights. Besides this, the fundamental principles of International Bill of Rights also mentions that these two basic human rights are the foundation of freedom, justice, and peace around the world. For whom this foundation is important, the foundation of freedom, justice, and peace, this is meant for all members of the human family. Once the term is members of the human family, it means we are talking about all persons living in any part of this planet. All belong to one family, and here it will not be denying a fact that even Indian philosophy refers to Vasudhaiva Kutumbakam. The entire universe is a human family. And this International Bill of Rights have picked up this idea that these rights of dignity and equality, which are inherent and inalienable, These are not only the foundation of freedom, justice, and peace around the world. It is important for all members of the human family. This is the first principle. The second principle refers to the disregard and contempt of human rights, which has taken place because of the barbarous act, and this had outraged concerns of the mankind. And because of this, a need was felt that there should be a new world where four kinds of human rights and fundamental freedoms be respected and be recognized. Here, once these terms have been included in the principles of International Bill of Rights, these words are coming from the statement of President Franklin D. Roosevelt, where Franklin D. Roosevelt has referred to four fundamental human rights and fundamental freedoms. What are those four freedoms? Number one is freedom of speech and expression and freedom of belief. The word which have been used, fundamental freedom of expression and belief, will be recognized. Besides this, there were other two kinds of freedoms, and these two kinds of freedoms are freedom from want, freedom from fear. Once we are talking about freedom from want, it refers to freedom from economic want. Economic want, there should not be any deprivation of anything in the life of a human being. And once we talk about freedom of fear here in the society, the third principle is that if individuals are not compelled to rebellion as a last recourse, rebellion against tyranny and oppression, human right must be respected by a rule of law. Therefore, human right is directly a subject of law. Human rights can only be protected by a rule of law, and it is one of the fundamental principles that rule of law is very important for promotion and protection of human rights. Otherwise, if rule of law is not applied in protecting human rights, people may revolt if there is great violation of human rights and fundamental freedoms. This caution has been made in the principles of International Bill of Rights. Promotion and development of friends, that is important, that if human rights are respected, it will lead to development of friendly relations among different nations of the world. Besides this, the next fundamental principle is that if faith has been reaffirmed in human rights and fundamental freedoms, these affirmation of faith is equally important for human dignity and worth of human person, as well as equal rights of men and women. And therefore, the United Nations Charter is determined to promote human progress, the social progress, and for the better standard of life in larger. In cooperation with the United Nations, the promotion of universal respect for an advancement of human rights and fundamental freedom. Besides this International Bill of Rights is also concerned that human rights should not be interpreted by people in different ways. The great difficulty was that after the Second World War, once the world was divided into two polarity, one is the capitalist countries of the world and the socialist countries of the world. The Western countries might have different kind of definition of human rights, different kind of interpretation of human rights, and the socialist countries also might have different kind of interpretation of human rights. This should not take place. Therefore, it was decided that once Universal Declaration of Human Rights is being made, This is for universal respect. Now, here it is important that prior to the establishment of the United Nations, human rights were applicable for the people in United Kingdom, United States, and France. This means human rights was respected within geographical boundaries of few countries of the world. But after the Second World War, it was thought that human rights should not remain confined to 3 geographical boundaries of the world. Rather, it should be available to every nations of every people, every individual in the society. In this way, there were 2 options, whether the word international be used or the word universal be used. International Bill of Rights refers to international, and why the word international has been used, it is an obligation of respect for human rights and fundamental principles by all states in their relationship with each other. It is international. It becomes a subject for promotion and respect for human rights in the relationship between different nations of the world. But even though it is International Bill of Rights, it requires that International Bill of Rights, this International Bill of Rights should not only be confined to the relationship between few states, rather it should be applicable to all people of the world. Therefore, the word universal was considered to be the better expression than international. Therefore, although we are talking about International Bill of Human Rights, but it starts with universal recognition for different kinds of rights and fundamental freedoms, because these are rights not only for the people of few countries of the world, rather it is meant for all nations of the world and all individuals which are living on this planet. Therefore, it was very much needed that there must be a common understanding of human rights and fundamental freedoms. Unless human rights and fundamental freedoms are not commonly understood, the full realization of the pleasures of the nation states cannot be possible. For it is of the greater importance for full realization of the pleasures with regard to human rights and fundamental freedoms that a common understanding of human rights and fundamental freedoms must be given. Despite we know that after the establishment of the United Nations, the world community remained divided into 2 parts, the Western and the communist countries. And the Western countries and the communist countries were giving their own interpretation of human rights. The Western countries were confining to civil and political rights, whereas the communist countries of the world were giving importance to the economic, social, and cultural rights. A long debate had taken place on the floor of the United Nations with regard to the meaning, but the great difficulty is that the International Bill of Rights was not complete by that time. It was in 1948, we had adopted only Universal Declaration of Human Rights, and these principles were put together, and all countries of the world have respected it. Besides this, it was also proclaimed, this was also proclaimed as a common standard of achievement. Once we are using the word common standard of achievement, it refers to common understanding of human rights and fundamental freedoms. Once it is a common standard of achievement, for whom? For all peoples and all nations. That is important. For all peoples and all nations, and to this end, all individual and every organs of the society keeping UDHR in mind, constantly in mind, shall strive by teaching and education, promotion and respect for human rights and fundamental freedoms. And it gives to an idea that even it is international, there is a role of individual, every organs of the society, and this will become clear once I will come at the close of my lecture on International Bill of Rights. Now, this appears to be contradictory. Some contradiction may appear in our mind that though it is International Bill of Rights meant for all nations of the world, and these all nations of the world have to recognize universal rights. These rights, since these rights are of universal nature, these are inherent and inalienable rights, these rights must reflect in the actions and behavior of all nations within its own territories and in relations with other states. And even not only the state government and states are responsible for this place, it is equally important for every individual, for every organs of the society to work towards the promotion and respect for human rights. At this time, the work was completed in 1948. Now, the first stage of International Bill of Human Rights was completed on the 10th December 1948. The one work was complete. But the great difficulty was that the idea with which International Bill of Rights had started, at that time it was thought that the first part of International Bill of Rights will only be a declaration of human rights. Why it was stated? Because once the United Nations the charter was being prepared, there were long discussion in the UN conference on international organizations, UNCIO. In that conference, though emphasis was put on International Bill of Rights, but many countries of the world has expressed caution. They fear that if human rights are included in UN Charter, we do not know how the United Nations, how different nations of the world will react to it. And they were very much cautious that we should not jump immediately towards a legally binding instrument, human rights, if these human rights are not acceptable to many nations of the world, there will be a great difficulty. The best compromise was that first, let us start with a declaration. Declaration will appear merely a declaratory nature. It is merely a recommendatory nature as a resolution of the General Assembly, and states will be free to recognize these Universal Declaration of Human Rights or not. An experiment was made with Universal Declaration of Human Rights. Once this experiment was successful, the international community started working towards legally binding instrument. What was there in this universal acceptance? That this universal declaration has been adopted, it has been recognized by different countries of the world. This Universal Declaration of Human Rights has been translated in more than 520 languages of the world. Universal Declaration of Human Rights and its many parts have been incorporated in 90 constitutions of the different countries in different nations. Even the Judge Hurst-Lauter Pact had mentioned that Universal Declaration of Human Rights is not merely declaratory or recommendatory in nature, rather it is a just cogence. And what is just law? It has got a legal significance. This Universal of Declaration of Human Rights, other important point is that there are certain articles which have incorporated both civil and political rights on the one hand and economic and social cultural rights on the other hand. Article 3 to 11 of UDHR refers to civil and political rights, whereas Article 12 to 27 refer to economic, social, and cultural rights. Therefore, it is important that International Bill of Rights, which starts with the principles, in principles it has included the seeds, the germs of civil and political rights, as well as the seeds of economic, social, and cultural rights. At the very beginning, once the Commission had started working towards Universal Declaration of Human Rights, it was decided for the first time that in order to prepare International Bill of Rights, the first phase, Universal Declaration of Human Rights, will be completed, and thereafter the work will start on formulation of legally binding instrument. It is interesting to know that on 10th December 1948, in one resolution, United Nations Universal Declaration of Human Rights was adopted, and in other resolutions of general and political rights are such rights which are judicially enforceable. On the other hand, economic and social cultural rights may not be judicially enforceable, rather it requires progressive development. If the nature and characteristics of these two rights are completely different from each other, it is possible that both categories of human rights to this fact, it was decided that there would be two different international covenants. One will be devoting to civil and political rights, and the other will be devoted to economic, social, and cultural rights. And in this way, the Commission on Human Rights, and in this ICCPR, interesting point is in these two documents were adopted in 1966 by the same General Assembly Resolution 220000. General Assembly Resolution 2200A included International Covenant on Economic, Social, and Cultural Rights, whereas General Assembly Resolution 2200. We must take into consideration that the words which have been used in these two covenants, they not only speak about relationship of observance, respect for human rights in relationship between two states, or respect for human rights and fundamental freedom within their own national territories or within national boundaries. Rather, it mentions that even people have, or the individuals have, has been taken up from Article 29 of UDHR, Universal Declaration of Human Rights. Not only mentions civil and political rights and economic and social cultural rights, it also mentions under 29 that there is the full realization of human rights will depend upon the duty towards other individual and duty towards society. Therefore, the thread is important, that if we put all these two international covenants all together, it is important to find that it refers to all the principles which have been mentioned in the preamble of the UDHR. The principles of the UDHR has formed the part of the preamble of International Covenant on Civil and Political Rights, as well as International Covenant on Economic, Social, Cultural Rights. Therefore, it must be understood that International Covenant does not have a separate of different identity from Universal Declaration. The crux, the main important, the fundamental aspects of Universal Declaration of Human Rights have been, and as it is clear from the title of these two covenants, civil and political rights includes only civil and political rights. On the contrary, the International Covenant on Economic, Social, Cultural Rights includes three kinds of rights: economic rights, social rights, cultural rights. These are the three different rights. But there are certain common provisions in both the international covenants. The first is that both is found in it is found in common Article 1. Once I use the word common Article 1, this Article 1, word by word, is the same ad verbatim. They have been used both on civil and political rights as well as international covenants on economic and social cultural rights. The common Article 1 states that all peoples have right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural rights. Cultural life. In this way, we do not find any kind of difference. If it is civil and political rights, it speaks determination of political status and freely pursuing economic and social cultural rights. It clearly denotes that political status as well as economic, social, and cultural rights are not two different things. They are very much integral to each other. Once this the other common thing in which are found in these two international covenants, which is a part of International Bill of Rights, that all now the member states have adopted Universal Declaration of Human Rights. This is one thing. And once these member states have they have ratified, they have put they are signatories, they have ratified the International Covenant on Civil and Political Rights. They are under obligation to respect civil and political rights in their own countries without any kind of discrimination, either discrimination on the basis of religion or political opinion. No kind of discrimination should be possible, and all these civil and political rights to which a member state has ratified, it is bound to respect these rights. And how they will do it? Now, this the common provision states that member states will adopt legislative measures. All nations are free to adopt legislation for promulgation, for respect for human rights and fundamental freedoms, which have become a part of responsibility of the member states, that they will adopt legislative measures according to their constitutional provision. There is no restrictions. Whatever constitutional provision a country has, keeping in view the constitutional provision, legislative measures can be adopted. And similarly, we find that many countries of nation, but no derogation is possible from few rights. The first right is right to life. Right to life cannot be taken away. The other is right against torture, cruel, inhuman, or degrading treatment or punishment. The next one is no one shall be held in slavery. Besides this, no one shall be imprisoned merely on the ground of inability to fulfill contractual obligation. The next one is this article: no one shall be guilty of offense which he had committed on account of any act or omission which did not constitute a criminal offense under national or criminal law. In this way, there are certain civil rights which are not within the purview of interderogatory clause of International Covenant on Civil and Political Rights. Here, this right, here, these international civil and political rights refers to all kinds of rights which may be available, which may be applicable to all the society, and there is no need of referring or mentioning those rights in a greater detail. What is most important in this International Covenant and Civil and Political Rights, that and it has designated a special organ for implementation. It is important that International Covenant on Civil and Political Rights includes the provision that a special organ for implementation of civil and political rights will be designated. And what is that? It is Human Rights Committee. Human Rights Committee has been constituted by the members in accordance with the provisions of the ICCPR. It is composed of 18 members of high moral character and recognized competence in the field of human rights. And they are elected by the competent parties to give effect to these provisions. And once these Human Rights Committee, which is constituted by the ICCPR, it is a treaty body mechanism. It has not been established by the United Nations. United Nations has had established Commission on Human Rights, but ICCPR had constituted Human Rights Committee. Human Rights Committee had been constituted by the ICCPR for the purposes of implementational mechanism. It has provided certain procedures how civil and political rights may be effective. The first important thing here it is that it mentions that all states parties which have ratified International Covenant on Civil and Political Rights, they will submit reports to the Human Rights Committee. That is a great process. That is a great procedure which has been adopted here. Every country of the world, and even India, is under obligation to submit its report or to the HRC what measures it has adopted with effect to the rights recognized and on the progress made in the enjoyment of these rights. It is not simply that a state has ratified, it has put signature on the text, or it has ratified. It requires implementational mechanisms. Certain procedures are to be adopted. And what are those certain procedures? The first procedure is that every state will submit its report, and this report will be examined by the Human Rights Committee. And after studying the report, the Human Rights Committee will transmit such general comments as it may consider appropriate to the state parties and its discretion to the Economic and Social Council. Human Rights Council gives its opinion and its comments on the state's report, and if some states have failed to observe respect for human rights and fundamental freedom, that are to be included in its national report before the Human Rights Committee. And if it has not done this work after few years, after 2 or 3 years as decided by the Human Rights Committee, it will be taken up, it will be considered, and after 2 or 3 years, states will again be asked to submit its report, what further action it has taken for the respect and promotion of human rights. This is a great responsibility upon the nations. And here it is the first important procedure which has been included in the text of the International Covenant on Civil and Political Rights. Now coming to the next procedure, which is important here. The second important procedure is that it is possible that one state will complain against other states that you are not respecting human rights in your country. And this provision is applicable only when a state has recognized the competence of the Human Rights Committee to accept the complaint of interstate nature. This is the second procedure. Procedure of interstate nature. One country complains against the human rights violation by another country. And it can only be possible once a state has accepted the jurisdiction of the Human Rights Committee. This is one rider. If a state has not accepted clearly or categorically the jurisdiction of the Human Rights Committee to accept this jurisdiction with regard to interstate complaint, the state cannot make a complaint against another state. For example, I use the word, if a neighboring country of India wants to make a complaint that this country has violated human rights and fundamental freedom, violation of the rights of International Covenant on Civil and Political Rights, this acceptance of jurisdiction is very much essential. Okay. And not only this, if country A wants to make a complaint against country B has also accepted it. And if country A says, I have accepted jurisdiction, this clearly means A can make a complaint against B state, and even a complaint against any other state will be admitted against country A. If I complain against another state will also get a right to complain against the same state. And behind it, it is very much important that the consent, the acceptance of the jurisdiction of the Human Rights Code is very much essential. Now, what is the process? If a state A has to complain against state B, first of all, it will write a complaint directly to state B that you are a member of ICCPR and you have violated the pledges that you have made under ICCPR. The country B will report to it, and both the countries are expected to settle this complaint amicably in a friendly manner. If it is not being accepted, or if it is not being taken up, is my voice audible?
Yes, sir. Yes, sir.
Yes, sir. Yes,
My voice
sir.
is audible to you?
Yes, sir.
Yes, sir.
Okay. Now, what I just wish to tell you here that I'm getting difficulty here. Yogendra, is my voice audible?
Yes, sir.
Huh?
Yes,
But
sir.
I'm
You are
not able to
audible.
see the faces of the participants.
Sir, all the participants have have own cell phone, sir. So,
Okay.
dear participants, please unmute your unmute
Pardon?
your camera and audio and video.
Audio and
Audio,
video.
if all of us will switch on audio, then there will be echo sounding, sir. That's why we should not.
Please give the response. Please give response.
Should I continue?
Yes, sir.
Yes, sir.
छत पर देख रहे हैं, सिनेरियो का आनंद ले रहे हैं।
नेटवर्क इशू हो गया।
अच्छा, कोई बात नहीं, आ जाएंगे आए। क्या डॉक्टर साहब सिनेरियो में है लगता है?
Verma sir, we are unable to hear you.
Yeah, I'm also getting difficulty how to connect.
Now
Yes,
it is
sir.
okay, sir.
Let me try it again.
क्या हुआ? कुछ सर को मदद करो। डिस्कनेक्ट हो जा रहा है। नहीं आपका माइक ऑफ करो। नहीं आपका माइक ऑन है। ऑन है, अपना आवाज ऑफ। माइक ऑन है क्या? डॉक्टर वाणी भूषण हैज रिच्ड सिनेरियो। दिन साहब
तो बाहर टहलना है।
दिन साहब पहुंच गए।
गेट को बंद कर।
क्या हुआ सर?
सर
कट गया?
नहीं आ रहा है। कनेक्ट हो गया सर।
आ रहा है?
कनेक्ट हो गया।
दिल्ली से कनेक्ट हो।
Now, am I connected?
यस सर।
Yes,
Okay.
sir, you're
Now I
audible.
start.
Yes, sir.
Yes. Am I audible?
यस सर।
Okay. Now, what I just want to say that there is provision of inter-state communications, and if there is any complaint by other states, it can be resolved friendly by other states. If suppose the problem is not resolved by inter-state communications, the matter can be referred to the Human Rights Committee, and Human Rights Committee will have closed meeting with the representatives of these two states, and the matter will be resolved. If the Human Rights Committee is successful in this procedure, it will prepare a report, and the report will be submitted to the Economic and Social Council. Besides this, the next important thing is that suppose even the Human Rights Committee is not able to resolve this problem of the inter-state complaint between two states with regard to violation of the pledges of the International Covenant on Civil and Political Rights, at that time, this ad hoc conciliation commission, and this ad hoc conciliation commission will place before the Human Rights Committee with a view to finding amicable solution of the matter. If the commission cannot report the issue to be resolved, it shall embody its finding on the question of fact and law, and this view on the possibilities of amicable settlement will be prepared by the human. What is important here for us is that International Covenant on Civil and Political Rights, which has identified all the civil rights, either with regard to right to life, liberty, equality, freedom against torture, and other kinds of rights. It has also included political rights as well. What are political rights? The political rights which have been identified, that there is a right to vote is a political right, and not only right to vote, right to hold public office after public office is also a political right of individuals. These political rights have been included under Article 25 of the International Covenant on Civil and Political Rights. And it has included not only right to take part in conduct of the public affairs directly or through freely chosen representatives. This means that it has mentioned about the democratic process of the political, and this right also includes not only right to vote, it also includes right to be elected at a genuine periodic election. This right must be genuine. It must be periodic election. The country can decide whether it will have election at 3 years or 4 years and 5 years. It depends upon the right, and it shall be the universal and equal guaranteeing the free expression of the will of the electors. These political rights has been included thereunder. Now, after recognizing these rights, Article from 28 thereafter in the International Covenant on Civil and Political Rights mentions the rights, mentions that in this way the rights will be, there will be implementational mechanism, and it will be very much effective. But it is very important that for the first time the United Nations decided that there will be a treaty-based regime of international implementation of human rights. If a country has not accepted, if a country has accepted the international covenant, it has to submit its report, and it is a great rider. The report card of every nation is examined, and it is being considered by the Human Rights Committee. It is a very important body under the framework of the international covenant. Now the question arises, if we are reminded of Universal Declaration of Human Rights, where it was stated that there is a common standard of achievement by all nations, by all people. Now here, it is important that all nations, and with all nations, it is important all nations and all individuals. Now question arises that if Universal Declaration of Human Rights refers to that there should be a common achievement by all, for the nations we have implementational mechanism at the helm of Human Rights Committee, whether individuals have certain rights or not. These individuals have the responsibility, but it is important that International Covenant on Civil and Political Rights does not give any right. This covenant does not speak about individual petition in international law. This is a new term, whether individuals can reach to the international forum for recognition of these rights. Once International Covenant on Civil and Political Rights was being prepared, the discussion were held that if we are going to accept certain procedures, whether we should have one procedure with regard to individual petition or not. This was very much controversial provision, and it was said that if this provision is included in International Covenant on Civil and Political Rights, many countries of the world may have objection, and they may not like to join International Covenant on Civil and Political Rights. Therefore, it was decided by the ECOSOC, the Commission on Human Rights, and also approved by the General Assembly, that along with International Covenant on Civil and Political Rights, first optional protocol will be adopted. On 16 December 1966, this General Assembly Resolution 2200B adopted International Covenant on Civil and Political Rights, as well as first optional protocol to the ICCPR. Why these two different instruments were adopted? Number one, the reason is that if individual petition is not included in the ICCPR, it will be easy for many nations of the world to become party to it, and they will ratify international covenant on civil and political rights. So far as the provision about individual petition is concerned, it must be included in different optional protocol, and a member states, a state party to the ICCPR will have a choice to determine whether they would like to become a party to the first optional protocol to ICCPR or not. This means that if 10 countries of the world have accepted this optional protocol 1, it will become applicable. Now here it is that once a state parties have ratified first optional protocol to ICCPR, it would clearly mean that individual of that country will have a right to individual petition about violation of human rights. That is a very important. Many countries of the world, and even India, has not ratified the first optional protocol to ICCPR. Therefore, the Indian people do not have individual right to individual petition against the state with regard to if there is any violation of international covenant on civil and political rights. What is important simply is that once a state party has recognized or it has ratified first optional protocol to the international covenant on civil and political rights, the individuals of those countries will have a right to individual petition. Now, there are certain procedures with regard to individual petition. Once an individual wants to make a petition against its own government, first of all, it has to exhaust all domestic remedies. What are those domestic remedies? Maybe in India, if suppose hypothetical case, if India would have ratified first optional protocol, then the first requirement would have been that these fundamental rights must have been domestically exhausted, either under Article 32 of the Indian Constitution or under Article 226 of the Constitution. Once justice was not made to that individual, or even if the matter had not been decided by the Supreme Court or the High Court in this country, the other option is that the matter would have been taken up by the National Human Rights Commission or the State Human Rights Commission, and it must have been domestically resolved. And once there is a domestic exhaustion of all the remedies available according to the constitutional provision or the legislative measures in the country, then only individual can make complaint to the Human Rights Committee with regard to violation of ICCPR. Besides this, the procedure also includes two important points: that these rights of individual petition should not be abused. If the Human Rights Committee feels that this right of individual petitions are being made for the abuse of these rights, the case will be rejected by the Human Rights Committee. Besides this, the complaint should not be anonymous. It should be the name, the address, and all details of the complainant must be there. It is very important. If the individual petition is anonymous, it will not be entertained by Human Rights Committee. Once an individual has made complaint against its own government, then what the Human Rights Committee will do first of all, it will transmit this complaint to the state that this individual has made complaint against you, and the state government is under obligation to submit its report to the Human Rights Committee. What is the status? What is the fact? And this must be brought, because it is quite possible that once a person makes a complaint against another, other must be given an opportunity to be heard. and the state and the government will be asked to give its own view whether this is a fact, this complaint is true or not, and what is the position of the government on that particular complaint. Once this report or a statement of the government is made available to the Human Rights Committee under the provisions of the first optional protocol to the ICCPR, then thereafter the Human Rights Committee will have a closed meeting in which the representative of the state government will be given an opportunity to defend himself. He would be that person's whatever says, just telling yes, and that state will be given an opportunity to be heard, and thereafter the matter will, and the Human Rights Committee will make recommendation for the realization of these rights. If we look at this procedure, it is very important that individual is at the international level to make its own grievances, and its complaint will be heard by that it will be heard by the Human Rights Committee. The second was that other thing was that at latter stage the United Nations has the second optional protocol to the ICCPR. And what is the second optional protocol to the ICCPR? That it speaks about abolition of death penalty. It is important that it speaks about abolition. Those states who are parties to the second protocol of the ICC will be under an obligation to abolish death penalty in their own country. Now here, a student or a researcher on death penalty may take up the case that what is there in Article 6.2 of the ICCPR. In Article 6 of the ICCPR, I'm talking about Article 6 in reference to Optional Protocol 2 of the ICCPR on death penalty. Article 6 says every human being has the inherent right to life. This right shall be protected by law, shall be arbitrarily deprived of his life. It is very important, very good. What is the second provision under Article 6? In countries which have not abolished the death penalty, sentence of death may be imposed only for the most serious crimes in accordance with law in force of the time at the time of the commission of the crime, and not contrary to the provisions of the present covenant or to the Convention on Genocide. This penalty can only be carried out pursuant to final judgment rendered by a competent court. Now, I like to mention that Article 6 of the ICCPR says that if a country has not abolished death penalty, right to life is very important. It is right to life, and right to life cannot be taken away arbitrarily by any state. Right to life cannot be arbitrarily deprived of. But if a state has not abolished death penalty, it is under an obligation that it can continue accordance with the law in force, in accordance with law in most serious crimes. What is most serious crimes? In India, we have got the word rare of the rarest. And in such most serious crimes, in accordance with the law in force, death penalty can continue. Now, this is provision under Article 6. What Optional Protocol 2 of the ICCPR states that death penalty should be abolished. And it is an obligation. And this says that those states who feel that it should be abolished, they should do it. And in this way, this provision has been included and it has been brought on the floor. Now, this is all about International Covenant on Civil and Political Rights. Now I come to the second substance, that is economic, social, and cultural rights. If we look to the International Covenant on economic, social, and cultural rights, it is clear that even this International Covenant on International Covenant on economic, social, and cultural rights, this is clearly known that it is considered to be its realization is progressively it is progressively realized. It cannot be judicially enforceable, but once it was considered. An International Covenant on Civil and Political Rights also starts with the same preambular paragraphs of Universal Declaration of Human Rights. It is equally important for me to tell here that it is equally important for me to tell here that these economic and social cultural rights have also found expression in Universal Declaration of Human Rights. Economic, social, cultural rights have been identified there. And once these rights have been incorporated, how they will be legally binding, these have found expression in International Covenant on Economic and Social Cultural Rights. It also starts with the same provision of Common Article 1, right to self-determination. Second one is that nation states are under obligation to take legislative measures according to constitutional provisions for the realization of these rights. The legislative measures are to be adopted. Besides this International Covenant on Economic and Social Cultural Rights speaks about what are the obligations of states for the realization of these rights, and it includes several kinds of rights. First of all, there is economic rights. What are included in economic rights? Economic rights includes right to employment. Right to employment is the first important right, and this right to work, right to employment includes rights of everyone to the opportunity to gain his living by work which he freely chooses or accepts. It not only that if a state has ratified economic, social, cultural rights covenant, it will say, I am giving you the job and you do it. It is important that a person must be given an opportunity to gain his living by work which he freely chooses or accepts, and will take appropriate steps to safeguard this right. This right must be made available. A state has to think what would be the different kind of opportunities available to the people for seeking job in this country. Besides this economic rights also recognizes the right to everyone to the enjoyment of just and favorable conditions of work. It is not simply that the state has provided just and favorable conditions of work. It has to ensure what is to be ensured: remuneration, which provides all workers as a minimum with fair wages and equal remuneration. Wages must be fair. It must be equal remuneration. If in one state it is found that the wages are not equal among men and women workers, it is violation of International Covenant on Economic and Social Cultural Rights. There should not be any kind of distinction by providing fair wages and providing equal remunerations of remunerations. There should be safe and healthy working conditions. It is also important. An equal opportunity must be given to everyone in his employment to an appropriate higher level, subject to no consideration other than of seniority and competence. By seniority, he has right to be promoted in his employment. Besides this, the right to enjoyment of just and favorable condition also includes rest leisure, and reasonable limitation of working hour. It is not that a person will be working 7 days or 24 hours round the clock. There must be reason. Besides this, economic rights includes right to have a union and to establish national federation of those trade unions and other things. Besides this, there is right of everyone of social security or the social security. Besides this, a number of social rights have been recognized under this International Covenant on Social Rights, and it is with regard to right to family, which is the natural and fundamental group unit of any society, particularly for the establishment, and it is responsible for the care and education of dependent children. Marriage must be entered into with the free consent of intending spouses. It is included in International Covenant on Economic, Social, and Cultural Rights. A special protection should be accorded to mothers during a reasonable period before and after childbirth. It is with regard to maternity leave, and other kind of protection and assistance should be given on behalf of all children and young persons. Besides this, there is right to adequate standard of living for himself and his family, and there is right to enjoyment of highest standard of attainable standard of physical and mental health. Besides this, all these kinds of social rights, cultural rights, have been also included under this ICCPR, and this right includes that state parties to the present covenant recognizes the right to everyone to take part in cultural life. This cultural right has been included. This text of the cultural right has been included from Universal Declaration of Human Rights, and it has been incorporated in the ICESCR. Besides this, it has to enjoy the benefits of scientific progress and its application. If and beside this, to benefit from the protection of and scientific, literary, or artistic production of which he is the author. Now, this cultural right, it is coming very clearly to intellectual property right, that if due to in their own culture, if there is some moral interest or material interest with regard to the scientific or literary advancement or production of that culture right, all the benefit must be given to those individuals. In this way, these cultural rights have been included. Now, the next coming to the implementational mechanism. Now we have to understand that there is no human rights committee here under ICESCR. Under ICCPR, Human Rights Committee has been constituted to monitor and supervise the respect for promotion and respect of human rights and fundamental freedoms in accordance with the International Covenant on Civil and Political Rights. There was great difficulty. The framers of the International Covenant on Civil, Economic and Social and Cultural Rights had thought it very clearly that there is a need that all these rights has to be progressively realized. It may not be possible to have judicially enforceable these rights. These rights may not be judicially enforceable, but the states have to take measures for the progressive realization of these rights. Therefore, the procedure which has been adopted under this International Covenant on Civil and Political Rights, this is very clearly of soft nature, that states have to make recommendations or submit its report and social council. States will submit social council. Economic and social council may send the same report to the specialized agencies. The specialized agencies which are there with regard to education, for health or other matter, they will examine the country report of the states which have been submitted by the ECOSOC. Economic and Social Council sends the same report to the different United Nations specialized agencies, and this different specialized agencies will submit its report to the Economic and Social Council. This report is again examined by the Economic and Social Council, and Economic and Social Council will suggest and give recommendation to the states how these economic, social, and cultural rights can be realized. And if there is any difficulty, suppose there is any very poor country of the world which cannot realize because of paucity of resources, natural resources, it cannot realize many of the economic, social, and cultural rights of its own people, it can seek cooperation and assistance of the United Nations, and United Nations will come forward for the realization of these rights. In this way, the implementational mechanism has been was included in the International Covenant on Economic, Social, and Cultural Rights. It appeared for the first time that once these two legal instruments were included, we have been adopted, perhaps the work of the International Bill of Rights is complete, because it is not only the Universal Declaration, the first part, the second part, again subdivided into International Covenant on Civil and Political Rights, as well as International Covenant on Economic, Social, and Cultural Rights. But besides this, so far as the implementational mechanism is concerned, we find Human Rights Committee with periodic review of the reports of the states, as well as interstate communications, conciliation mechanism, as well as individual petitions because of first optional protocol of the ICCPR. Besides this, so far as International Covenant on Economic, Social, and Cultural Rights are concerned, here we find identification and the mechanism how these rights will be recognized and realized by the state, and the role of the Economic and Social Council and the role of the specialized agencies of the United Nations in supporting, in cooperating, and assisting the nations for the progressive realization of these rights. Now here, though the world community thought that perhaps International Bill of Rights is complete, but again there were certain doubts. What was the doubt? The doubt was that if there is one Universal Declaration of Human Rights in this International Bill of Rights, and although because of the bipolar situation of the world into communist states and these capitalist states, that we have adopted civil and political rights covenant, as well as economic and social cultural rights, it is true, but all these rights are universal rights. Second one, these are indivisible rights. In 1966, we had divided civil and political rights at the one end and economic, social, cultural rights on the one hand. On the other hand, now the World Conference on Human Rights in 1993 has categorically stated that all these rights are indivisible. We have done a mistake in 1966, but we must realize, so far as the realization and implementation of these human rights and fundamental rights are concerned, it is the demand, and it should be accepted, that all rights are indivisible. They cannot be divided, as well as they are interdependent upon each other. Interdependence of these two rights are important for International Bill of Human Rights. Why? Because we are reminded of very critical debate on the floor of the United Nations, that once the country report of the states were being examined in the Human Rights Committee, many states used to say that civil and political rights are not very important. Economic, social, cultural rights are more important than civil and political rights. Therefore, if a country has not respected civil and political rights, no punishment should be given to that state. No political rights and Economic and Social Council. Similarly, there is a provision of interstate complaint and communication between states with regard to violation of the International Covenant on Economic, Social, Cultural Rights, Conciliation Commission. But unfortunately, there is no provision with regard to individual petition in international law. Why there is? Because these rights are not judicially enforceable. Because if the individual petition is to be recognized, its integral part is that there must be domestic exhaustion of local remedies. If exhaustion of local remedies is not possible according to the constitutional provision in a country, how individual petition can be recognized? In this way, International Bill of Rights is complete today, and we should think of it. The only difficulty is that in educational institutions, we are taught about Universal Declaration of Human Rights. We are taught about International Covenant on Civil and Political Rights. We are taught about International Covenant on Economic, Social, and Cultural Rights. We do not hear any word about International Bill of Rights. Though it is true that if a researcher goes to try to find out the reference of International Bill of Rights, the recent development is that the new word has been coined, International Bill of Human Rights. Now, since it was earlier International Bill of Rights, therefore it is. Now, the pledge that was made at the beginning of the United Nations that there should be formulated human rights, because United Nations stands for promotion and protection of human rights. It is one of the purposes of the UN Charter. Therefore, it is a greater responsibility that there should not only be universal declaration, there should be interstate communication, international obligation towards respect for human rights and fundamental freedom. The words which were incorporated under Article 55C and 56 of the United Nations Charter, they become very true today. And in this way, the international community has thought of a certain kind of mechanism that these human rights and fundamental freedom will be available around the world, and there would be international machinery for realization of these rights. And this International Bill of Human Rights can be taken into consideration by Office of the United Nations High Commissioner for Human Rights. This body, Office of the United Nations High Commissioner for Human Rights, was constituted by virtue of Vienna Declaration adopted by the World Conference on Human Rights in 1993. And it is the responsibility and the Office of the High Commissioner of Human Rights works according to it, and it has started working with a special rapporteur wherever there is problem of violation of human rights in any part of the world. This Office of the High Commissioner for Human Rights sends a special rapporteur to examine the report, to talk to the government officials, to the people, the victims in that society, and to submit its report to the Office of the Human Rights High Commissioner. Now, why I have taken this topic today because it is very important for the faculty members to understand the nature and scope of International Bill of Rights. International Bill of Rights is very important. We miss this bus, we miss this link just by referring to UDHR or ICCPR or ICESCR. We remember these two international covenant, because from the date of their adoption or of day of their operation in either in 1976 or the adoption of UDHR in 1948. But if you ask someone when International Bill of Rights was adopted, there is no word, because International Bill of Rights is not a document which was adopted at one stroke. It was progressively developed. The work had started in 1946. It completed in 2013. It has taken so much year. If earlier we were thinking that there were from 1948 to 1976, within 28 years, we have completed International Bill of Rights. But the fact is that with the ratification of the first protocol of the International Covenant on Economic and Social Cultural Rights, it has taken 65 years in the progressive development of International Bill of Rights. Therefore, it can be submitted that International Bill of Rights comes into effectively comes into operation from 5th May 2013. And this is the message which I wish to convey in my present presentation before the faculty members in this refresher course. With these words, I thank you very much to the participants. And I would also welcome if there is any question by the participants. I'd be very much happy to answer.
Sir, here's a question, sir.
Yes.
Sir, you said that now IBR represents.
First of all, would you like to introduce yourself?
Thanks, sir. I'm registered here for refresher course at serial number 8. My name is Dr. Nutan Kumari. I'm from Department of Political Science, TPS College, Patna.
Okay.
Sir, here is the question. Sir, you have been, this lecture was really focusing on International Bill of Rights. Sir, you said that now it has become International Bill of, it became International Bill of Human Rights. Can you tell me?
Well, it is difficult for me because if I have gone through the records of the International Conference on International Organization, it is UNCO documents in 17 volumes. And in these volumes, the words were first of all used International Bill of Rights by the Preparatory Commission on United Nations. And we started working on it. And it continued. But in some provisions in 1996, I was looking into some of the documents of the United Nations on human rights. We found the word International Human Rights. And we were not, I was not able to trace in which year or under what circumstances the words were used. Perhaps it may be that in the United States, there is a Bill of Rights. In the United Kingdom, there is Bill of Rights. And there was also view of the international community that